Welcome to this comprehensive presentation on unpaid internships in Washington State. In 2026, Washington has the highest minimum wage in the United States at $16.66 per hour, making misclassification more expensive here than anywhere else. Yet unpaid internships remain legal if they pass the Ninth Circuit's primary beneficiary test. The Fair Labor Standards Act has been the cornerstone of American wage law since 1938. Section 6 establishes the federal minimum wage at $7.25 per hour. Section 7 requires overtime pay at 1.5 times the regular rate for hours beyond 40 in a week. The critical question is whether the intern qualifies as an employee. The statute defines employ broadly as to suffer or permit to work from the Supreme Court case Walling versus Portland Terminal in 1947. Washington's minimum wage of $16.66 per hour applies alongside federal law. The controlling legal standard for unpaid internships in Washington comes from Benjamin versus B&H Education, decided in 2017 by the Ninth Circuit. This case replaced the older rigid test with the primary beneficiary test. Courts weigh all 7 factors together to determine who primarily benefits. The Department of Labor adopted this approach in Fact Sheet number 71. All federal courts in Washington must follow Benjamin. Factor 1 examines whether both parties clearly understand there is no expectation of compensation. A written agreement signed by both parties is the strongest evidence. If an employer makes any promise of compensation, the analysis shifts toward employee status. Even small payments can be problematic. The Department of Labor emphasizes that the understanding must be mutual and documented. Factor 2 asks whether the internship provides training similar to an educational environment. This means structured mentorship, rotation through departments, and regular feedback. The intern should be acquiring new knowledge, not performing repetitive tasks. The Benjamin Court emphasized that training must have genuine educational value. Factor 3 considers whether the internship is tied to formal education. Academic credit from an accredited institution is the strongest evidence. Washington institutions like the University of Washington require defined learning objectives for credit. The Second Circuit in Glatt versus Fox Searchlight established that academic credit is a significant indicator of a valid unpaid internship. Factor 4 evaluates whether the internship accommodates the academic calendar. The schedule should work around classes, exams, and semester breaks. If the employer requires work during exam periods, the relationship looks like employment. The Department of Labor states that duration should correspond to academic terms. Factor 5 requires a limited duration tied to specific learning objectives. A defined end date is essential. Open-ended internships suggest the employer needs ongoing labor. The program should end when educational goals are achieved, not when tasks run out. Factor 6 is often the most critical. The intern's work must complement, not displace, paid employees. If the intern answers phones or enters data that a paid employee would otherwise do, the balance tips toward employment. The Benjamin Court said even routine work can support an internship if the educational purpose remains primary. Factor 7 examines whether the internship carries entitlement to a paid job afterward. A written agreement must explicitly state there is no promise of future employment. If the internship serves as a probationary period, it is employment from the start. Now the Washington-specific picture. At $16.66 per hour, Washington has the highest state minimum wage in 2026. For a misclassified intern working 30 hours per week for 12 weeks, this amounts to nearly $6,000 in back wages. A successful plaintiff recovers double that amount, plus attorney's fees. Washington's Department of Labor and Industries enforces wage laws independently. Let us close with key takeaways. Document all 7 primary beneficiary factors in a signed agreement. Washington's minimum wage is the highest in the nation. Benjamin versus B&H Education governs the Ninth Circuit. Nonprofit and government internships follow different rules. Monitor dol.gov and lni.wa.gov for guidance changes. Thoughtful program design and documentation are your best defenses against misclassification. Thank you.